Let us understand what are the types of contracts that are available. First one is the express contract, and express contract is a contract in which the terms of the agreement are clearly and explicitly stated in either writing or orally. So when there is a explicit, very clear expression of a contract when it is done, whether it is writing or an oral, that is called an express contract. Next comes the implied contract. An implied contract is a contract in which the terms of the agreement are not expressly stated, but can be inferred from the conduct of the parties involved. So, implied means there is an implication that there is a contract in this, that you are supposed to do this. Okay, that such sort of contracts are called implied contract. When it is clearly mentioned, expressed contract means when it is written in words. Such contracts are called expressed contracts. But it is not written in words, but it means it is implied. It means it is called a implied contract. Okay. So, for example, what are implied rules or regulations or contract? What, for example, let me take right to life under the Indian Constitution. So, it is not written under the right to life in the Constitution. It is which says that giving food, giving healthy food, giving good shelter, good drinking water is a part of right to life. But when you go look into the court cases, in the court cases, it is implied that if a human being has to survive, has to live, then he needs good food, good water, and good shelter, right? So that is called, it is not expressed in words, but it is implied. For a human being to survive, what all you need? Food, water, shelter, all of these are implied rights. Okay. So just like that, there may be certain contracts in which they have not clearly stated or mentioned in words as to what they mean, but it is implied. Let me give you an example. In an agreement between the building owner or a property owner and a watchman, even though he is not mentioned clearly, saying that you have to be awake the whole night. When they say you are a night watchman, it is implied that you have to be awake for the whole night, right? Even though they have not mentioned that you have to be awake from from evening 6 to next day morning 6, even though they have not mentioned it in words, when they are hiring night watchmen, it is so implied that you are supposed to be awake. So that is called implied. If they have mentioned it in words, well and good. But when they have not mentioned it in words, it becomes implied. So you know the difference between the express contract and the implied contracts now. So express contracts is something where it is clearly mentioned in the words itself. And it is easy to understand because it's in white and black in paper. It can be read. But implied contracts are something that is implied, that has to be understood on your own, right? When you're applying for a night watchman duty, then it is that you have to understand on your own, even though if they have not mentioned that you have to be awake for the rest of the night. Okay, so that is called implied. That is a contract. Okay, so unilateral contract. A unilateral contract is a contract in which only one party makes a promise and the other party performs an act or abstains from performing an act in response to that promise. So in unilateral contract, what happens? Only one person, it has to be performed from one person. The other person has to stay calm until unless, because that is what the contract mentions about, because it is a unilateral contract, only one side obligation. There's no two-side obligations. Okay, so you can also enter into such contracts too. Next is a bilateral contract, which is between two or more people, and both the people are under the obligation to fulfill the terms of the contract. Okay. Moving on, we have valid, void, and voidable contracts. So, yeah, what is a valid contract? Valid contract is a contract that is legally enforceable. Valid contracts doesn't have any legal flaws in it. It is legally enforceable and it meets all the essential elements required for a contract to be valid, such as what? An offer is made, a valid offer is made, an acceptance is received, consideration is fixed, capacity to contract is there for the parties because they are major, they are of sound mind, and they can get into a contract. Next is the free consent. There is a free consent. Only then it is called a valid contract. So it is legally enforceable and all the essential elements of a contract is present. Okay. Next comes the void contract. A void contract is a contract that has no legal effect from the beginning. So from the very start of the contract itself, that particular void contracts means no contracts. Void contracts is equal to no contracts because from the very initial times, from the very beginning of the contract, that contract is not enforceable by law. And such contracts cannot be considered as a valid contract. And the parties cannot claim any legal rights in this contract. Okay, because it is void. From the very initial stage, from the very beginning stage, this particular contract is void. Next comes the voidable contract. So this can be made voidable. That is, the voidable contract is a contract that is valid at the time of the formation. Okay, it was valid when it was made, it was valid when it was signed, but can be cancelled or voided by one of the parties due to certain legal defects. If there is any legal defects in the contract, and see, when the parties, the one party who signed the contract didn't have any idea that it was made by fraud, coercion, undue influence, misrepresentation, but after 6 months of getting into contract, he or she got to know that this was done by fraud, coercion, in under influence and misrepresentation. What do then? You can go to the court and you can nullify the contract. So that is called a voidable contract. When it was signed, when they got into the contract, it was valid. But later on, as time went by, people or the party, one of the party got to know that it was caused by, or they got the signature by, or they have cheated this other person. Either it can be fraud, coercion, undue influence, misrepresentation, or mistake, any of these. So then this can be taken to the court and told that I didn't know that they are fraudulent people. They have gotten me into this contract and now I am into it. So I don't want this contract to be active. I need legal remedies for it. They can go to the court and they can get this contract voided. Okay, it is called voidable contract. Next is what is breach of contract. So breach of contract is a violation of any of the agreed upon terms. When you're signing the contract, you've agreed upon certain things, right? You would have agreed upon following the rules, regulations, whatever is said, that you will be giving the consignment within 10th of every month and you will be receiving the consideration before the 10th of every month. There are certain things that you have to follow. In case if that is not followed, it's a terms and conditions that are binding in the contract are not followed by the parties. What happens then? It becomes a breach of contract because you've accepted for something, but you're not following it. So you're breaching the contract that you have gotten into. Breach is nothing but it is not following, so it could be anything from late payment. As I already mentioned, breach can be anything. Falling short of what you have promised, not following what you guys have promised in the contract. Okay, that is called as a breach. And it could be anything, as I already mentioned. It can be late payment to a more serious violations also, such as failure to delivery as promised, because if they don't give you the raw materials, you will be not in a position to create the finished product. So raw materials received in the correct time is very important for your business to move on. As I already mentioned, it can be a truckload of leather, it can be a truckload of paper, whatever it is, for whatever purpose you are using it. But you have a contract with the other party where he is supposed to send the consignment every month in a particular date. And if he fails to do so, then it becomes a breach of contract from his side. And a contract is binding and will hold weight if taken to the court. So if it can be proved that the contract was breached, the remedy would generally to be give the victim what they were initially promised. So they would have mentioned if breach happens, what would they do? They would have agreed upon that in the contract also. So they would be following the same method. A breach of contract is not considered a crime or even a tort. The punitive damages are rarely avoided for failing to perform promised obligations. So the breach of contract is not considered as a crime. It cannot be treated under criminal procedure code, nor it is considered as a tort also. Okay, but there's only punitive damages. Okay, and they're rarely awarded for failing the performed promised obligations, because when you're in a business, there may be things that goes up and down. Okay, so maybe you have yourself not received the consignment for someone else. So what you can do, you cannot send the raw materials, because if there's a genuine reason and you've not done it on purpose, no one can do anything. So it is a breach of contract is a flaw, but still you have to pay certain damages for it.